very specifically, basing on Darya judgment, amended, clear, and they also, yes, the, kindly see page 171. They give the roster, bottom page, bottom of the page. Roster begins here. Appointments under this rule shall be made in the order of rotation specified below. In a unit of 100 vacancies. Yes, yes. Amended. What is relevant for us is this clause. This table itself has been amended. Earlier, this table used to consist of horizontal reservation categories also. Women, sports persons, ex-servicemen, people with benchmark disabilities. Now that is removed. Kindly see. First post is open competition. Second is SC, so on and so forth. There, no, page 171. This is the roster. Deleted. In principle, practically they have not done it. In principle, this is the roster. Even if this roster is said to be legal, it is in accordance with Darya judgment. None of the horizontal reserved categories, like women, persons with benchmark disabilities, sports persons, ex-servicemen, none of them are here. Yes, kindly see the first page. This is the notification. Now they explain from page 174 onwards, in the new scheme of things, how horizontal reservations will have to be implemented. For our purposes, kindly see page 175. 4 and 5. 5 is very clear. They say special reservations will not be there. After final select list, if you find out that adequate number of women or ex-servicemen or sports persons or persons with disabilities are not there, then the question of reserving certain posts will arise. So the most meritorious candidates will remain. From the bottom of the list, they will be deleted. That is the scheme. That is explained. Illustration is there. Kindly see. Paragraph 6. Only if there is any shortfall, the requisite number of scheduled caste women shall have to be taken by deleting the corresponding number of candidates from the bottom of the list relating to scheduled castes. To this extent, horizontal special reservation differs from vertical social reservation. Thus, women selected on merit will within the vertical reservation quota will be counted against horizontal reservation for women. So clearly, there should be a merit list first, without any following any reservations for horizontal reservations. If adequacy, then the adequacy will be counted. If number of women are not there, less than 33%, then the lowest merit candidate, male candidate, will be shortfall. Yes. Shortfall is the only then reservation will arise. So at the time of initial preliminary notification, you cannot say that I'll have 3 women as municipal commissioners, 1 woman as so and so, ASOs, etc. You cannot say that. Only after select list is prepared, if there is shortfall, then you will have to remove the lowest merit male candidate and place in the. Yes, example is given. Assistant section officers in the secretariat are a special cadre. Certain posts are there. Suppose illustration 10 posts are there. 10 posts you can reserve for SC, ST, BC. That is all. After that, there is no reservation. You will have to go for the merit list. After preparing the merit list, suppose there are no 3 women. 3 women are not there in the list. Then it comes for implementation of horizontal reservation. That is the correct time. Section officers. Vertical reservation will be there. Exactly. Suppose if it is a separate cadre, suppose ASO is the separate cadre, basing on reservations that you are earlier following, suppose if it is treated as a separate cadre, you will have to first see whether there is any shortfall of women candidates, shortfall of sports persons. Yes, yes, yes. Similarly, every cadre, similarly, you will have to consider that computers are there, they can do it. That is list is given. I'll just kindly see the notification. That they will have to clarify what are the cadres, how they have identified these posts. $36 million. No, not reservation. I'm saying, Millard, I'm talking about the number of posts. Page 36. Total executive posts are only 8. Top Millard. Total 8. They'll have to be taken as a cadre. Yeah. I'm just explaining for the purpose of explaining. No, these are the post codes, Millard. They are not in seriatim. Yes, they are not in seriatim. Non-executive posts are 45. First page 36. So reservation will have to, these are all statewide posts. So reservations will have to be implemented for these 45 separately. That is what they are doing. Executive posts, totally 325. Yes. For 325, they'll have to prepare a merit list basing on 100-point roster according to them. If there is shortfall, then question of horizontal reservation will arise. They consider category. But the problem is, when it comes to reservations, they have categorized. That is what I am pointing out. But before I going into that, only 2 paragraphs from the policy 77. Kindly see page 175. Kindly come to illustration, paragraph 6. If 15 posts are reserved for SCs, of which the quota for women is 5, 15 SC candidates shall have to be first listed in accordance with merit from out of the successful eligible candidates. If such list of 15 candidates contains 5 SC women candidates, then there is no need to disturb the list by including any further SC women candidate. On the other hand, if the list of 15 SC candidates contains only 3 women candidates, then the next 2 SC women candidates in accordance with merit will have to be included in the list, and corresponding number of candidates from the bottom of such list shall have to be deleted. so as to ensure that final 15 selected SC candidates contain 5 women SC candidates. SC, only SC. Very clear. If the list of 15 SC candidates contain only 3 women candidates, then the next 2 SC women candidates in accordance with merit will have to be included in the list, and corresponding number of candidates from the bottom of such list shall have to be deleted. Otherwise, what happens is, well, if the bottom of the list for each category is not considered, what happens is this horizontal reservation will affect only one category. That problem will be there. Yes, yes. Deleted. So what does this mean? Now take this illustration itself as a notification. If there are 15 posts, you cannot make any reservation for women. You cannot indicate that there is any reservation. You can only say 33% posts are reserved at the time of merit list. Before appointment, we will see if there are XI. So first point is, on facts, there cannot be a notification which may not reserves any posts for horizontal categories. There cannot be such a, but now kindly come to the notification. Lord, Annexure 1 is the breakup of vacancies. Page 57. Municipal commissioner post, there are 4 posts. OC1, ST, OC1 local to ST1. Totally, they say 4 posts are there. Kindly see after that. Among the 4 vacancies, the following vacancies are reserved horizontally. Persons with benchmark disabilities, 1. Women OC, 1. Women ST, 1. So they have reserved for women. Basing on roster points, which is not existing, I have shown to your lordships the roster. According to the roster, there is no reservation, horizontally fixed reservation. There are no roster points. At the time of first notification, you cannot fix any roster. Now kindly see what they have done. They have fixed roster for both persons with benchmark disabilities and women. Next, kindly see sub-registrar. Sub-registrar, there are 16 posts. 16 posts in all the zones. They have provided reservations horizontally. For hearing handicapped, 1 post. For hearing orthopedically handicapped, 1 post. Women, among women, OC 1 post, BCD 1 post. The above vacancy is reserved to PBD. Zone 4, among the 9 vacancies, the following vacancies are reserved horizontally. Persons with benchmark disabilities, orthopedically handicapped, 1 post. Women, OC 2 posts, BCD 1 post, and ST 1 post. It flies, all this flies in the face of Darya judgment. And obviously, well, let's suppose it is becoming vertical. It has become vertical. They have equated it to vertical, which cannot be done. Yes, it has been deleted. And what happens? How Article 14 is affected? Kindly see 16 posts are there. Of these 16 posts, except SC reserved post, ST reserved post, BC reserved post, suppose I am an OC candidate. I can compete for any of the posts. But now what is happening? I cannot compete to these posts which are reserved vertically for the purpose of women, persons with benchmark disabilities, and sports persons or whatever. So, here too, others, I'm not taking much of the your lordship's time, so I'm focusing on certain things. Now, what is Article 14 is offended. That is what I was submitting, my lord, initially as a prelude to my argument that Article 15 and 16 are, my lord, an exception to Article 14. They'll have to be very strictly, my lord, interpreted, and you can't maneuver it or manipulate it in such a way that, my lord, open candidates are affected. That is my argument. My lord, better, it can be better illustrated if I, my lord, draw your lordship's attention to the deputy Tahsildar's post. Next page. Page 58. Well, totally, there are 114 deputy Tahsildar's posts in the state. Now, for OC, that is unreserved, without any vertical reservations, there are 38 on the top. Kindly see. But what they have done below this table, in each zone, the reservations supposed to be horizontal are they are given vertical reservations. So what happens? Take a male candidate belonging to, suppose, well, open category, OC. Now, OC candidates, according to law, is supposed to be free to compete to any of the 38 posts. He is free. That is what equality clause is. But in effect, what is happening? For all these posts, note, below the note, these posts are reserved for women, PBD, women and PBD here. So, which means for these posts, an open category male cannot compete. I'll just show here. Zone 1, kindly take. Zone 1, women, OC 5. So, of the open category 38 posts, 5 are reserved in Zone 1. Some at places it is. Yes. Sometimes it is exceeding according to my calculation, but that is not the criteria. You cannot say at the threshold when everybody can compete, you can't stop me from competing and say women reservation is satisfied because 33% are there. That cannot be the argument. Because that is why I am pointing out this. Suppose, take BCA.
May I interrupt? I'm sorry to interrupt you. In second writ petition, counter on behalf of government is filed. Essentially, I'm sorry to interrupt. Essentially, the main allegation or main contention of APPC in their counter is that they received indents, what you call vacancy-wise this thing from departments, and depending on the requisition sent by the concerned departments, they issued this notification. And therefore, in second matter also, counter from government is required. That's the reason why I interrupted my learned friend Millard. And insofar as urgency part is concerned, Millard, at this stage, they will not be applying roster points for the purpose of appearing for main examination. Incidentally, if your lordship sees, Millard, in second writ petition, 4 individuals are petitioners before this honorable court. As against 4, only 1 is qualified in screening test. I am not trying to put it on the ground that others are not qualified. The reservation will be made applicable at the time of after completion of main examination and after completion of computer proficiency test. Therefore, at this stage, there is no urgency for them. Anyhow, everyone, irrespective of their reservation category, all the candidates who are intending to participate in the selection process have to appear for main examination. For a moment, may I invite main examination. It is not their case that they are not. But depending on the state counter, your lordship can decide at that stage is my respectful submission. Instead of considering for interlocutory as well as main separately, therefore my request, your lordship may, for my sake, your lordship may request your lordship to see page 24. Yes, yes. With regard to procedure, though there is no dispute, I am only trying. But 4633 first only. I am only trying to satisfy this honorable court. With regard to procedure, I am only trying to show to this honorable court to satisfy the para 4 minute. The screening test preliminary examination will be held on so that is over minute. Based on the merit in the main written examination, the candidates will be shortlisted to the main examination in the ratio as may be decided by the commission at an appropriate time. That stage is over. And now 23rd of this month, main examination will be conducted. Therefore, my learned friend, the petitioner's urgency, anyhow, they will have to participate in the main examination. Their contention is that some posts which ought to have been treated as, ought not to have been treated for the purpose of horizontal reservation has been notified as horizontal reserved posts. Therefore, their right to participate in for or their right to compete for those posts is curtailed. Consequently, Article 14 is violated, is sum and substance of their argument. For that matter, second writ petition also with respect to horizontal reservation, there is an allegation. And therefore, with respect to that, to answer, but rightly or wrongly, counter affidavit on behalf of. Yes, that's what I am trying to. No, such a contention, such a in this case, such a contention is not available to.
No, my humble submission is this. That is not the sole apprehension. Kindly see. The notification, there are several grounds. First ground is, as learned Advocate General has pointed out, the horizontal reservations, which cannot be there in the preliminary notification, have in effect become vertical reservations. Because of that, candidates have lost their opportunity to apply itself. Second stage, selection is the final stage. What happens? You have reserved certain posts to women or PBD. So the candidate will have an apprehension that there is no possibility of being selected. So he cannot make an application. So if the examination is conducted, we will be further perpetrating the illegality. In the original notification itself, there is illegal.
Petition is not a pro bono, my lord. Admittedly, petitioner in this case participated in the screening test. He is qualified and he will be allowed to participate. And there are 800 and odd posts. It's not as though I am only conducting examination for a particular group, 3 or 4 posts. That's the reason why I am only trying to submit, my lord. Absolutely, there is no urgency for the purpose of considering interim application. The matter can be thrashed out finally after inviting counter. Of course, there is a lapse on the part of first respondent, but there is no requirement of any stay of examination is my respectful submission.
When there is prima facie
petitioner
material before
once again I reiterate, madam, petitioner is not espousing the cause of other individuals. It is not the case of the petitioner that he is being prevented to participate in the main examination. This I am only submitting for the limited extent of their request on interim application, not on main. I am not trying to say that they are not. No prejudice would be caused to them. And at any rate, I cannot say that they are not entitled to challenge the notification having participated, because they filed this writ petition immediately, I think 1 month after the notification. Before screening test, I think subject to correction, before screening test itself, they have filed writ petition.
What I am saying is, basically, this is a classic case where prima facie there is already material before your lordships, both by way of material that we have submitted to your lordships, and also the government has submitted material showing that 100% that horizontal reservations posts are, rosters are there. They have reserved posts, which is against Daria judgment. I will not go into Savarwal judgment. That is altogether a different issue. Their chances were already scuttled. Yes, kindly see page 57. OC. There are 3 posts. Kindly see what has happened. Persons with exactly. So what happened? I'll just explain. This is how reservations will be followed. That is their promise. This also gives rise to legitimate expectation on the part of a person with benchmark disability. A person with benchmark disability is reserved 1 post, which cannot be there. So what is happening? This petitioner has lost that post. On the basis of examination, they will make a select list. But select list segregate. Suppose I opt for certain posts. For suppose 1 post.
I'm sorry to, if at that stage it is always open to the honorable court to give direction, appropriate directions. If it is held to be wrong, if the reservation or roster adopted by the respondents is held to be wrong, it is always open to the honorable court to issue appropriate direction. That's the reason why I'm not trying to seek longer date. At least if it is adjourned for 1 week or 10 days, I'll be only for the purpose of addressing their concern on the interim order. I submitted that minute. Last grant me 10 days or 2 weeks time. I'll be filing counter on behalf of first respondent, and matter can be thrashed out at that stage.
He cannot apply. No, what happens is, as it is, the whole selection, if I may use the term, I'll illustrate, Millard. It is already bungled up. It is already become illegal. The whole thing has become vitiated because of this illegality, the original notification itself. Now what is happening? Basing on this illegal notification, you are inviting certain persons selected basing on preliminary examination to come and write the main examination. So lakhs of people will come and compete. Well, another list will be prepared. All this is perpetration of illegality from one step to the other. No. Suppose I'll just explain. See,
Yes, sir.
no. That is not
All
correct.
the individuals will be participating in the main examination. In fact, applying roster and apply that second stage after
It has
thereafter.
already been applied. That is my whole problem. There is suppose. Let us take an illustration. There are 100 posts. Suppose there are only 100 posts.
To make myself clear, Milord, I'll point out only one aspect. It is not the case of the petitioner that he is being prevented from participating in the main examination for 800 and odd posts.
No, that is my precise case.
At the stage of selection, that is after qualifying in the main test and after qualifying in the computer proficiency test, then this applying roster points and all those things will come into play. At that stage, and I'm not trying to say that I'll be dragging the matter till that time. At least before main examination final list is notified, it is always open to this honorable court to issue appropriate directions if at all if I am found to be wrong in adopting. $57 million. Yes, madam. Yes, madam. Yes, madam. 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 Yes. Yes. If, may I say one thing, madam? If this roster point for women is wrong, held to be wrong, then he is eligible. Then he is eligible. But examination will be common for one and all. Yes, ma'am. Yes, ma'am. I will have to consider his case for that position also. Yes, ma'am.
What happens is,
in a case where it is not a public interest litigation, they are espousing their own cause, their right to participate in the main examination. They are not trying to say that they are being prevented to participate. But in this case, Mirad, subject to correction, 4 lakh and odd individuals have participated in the preliminary test, and out of them 92,250 are qualified. They will be appearing for examination on 23rd. If at this stage, if that's the reason, I'm only trying to satisfy this honorable court about the interim.
Just one sentence I leave to your lordships. Malad, there are 100 posts, Malad, OC posts. Now, what has done? They have done an illegality by reserving 33% posts that lordships have seen. So, I am curtailed from competing for the 33 posts. I am now curtailed to compete only to the number of 66 posts. So what happens? My performance, Malad, will be affected. This will have larger ramifications. It is not just about the petitioner. Suppose I am one of the aspirants. Suppose there are 100 posts. The way that I prepare for the examination is different. If there are 66 posts, the level, the degree of Malad attention will be different. So, secondly, practically what happens is, now suppose all the candidates write for the main examination. How are they going to select it? What is the purpose of this selection? You can't correct it. I'm not objecting. But meanwhile, what I'm saying is, let them not precipitate the issue by conducting main examination. What will, but no prejudice will be caused to the government when prima facie this notification is illegal. Even it is to the benefit of the government, because it has to uphold Article 14 as well as 16 and 15. It is for the benefit of the government also to make reservations in a proper manner in accordance with the judgment of the Honorable Supreme Court. Suppose the examination is deferred by 10 days, during which time they can file a counter affidavit, heaven are not going to fall. But if the exam is conducted, you will be perpetrating the illegality. When we know that this is illegal, how can you, on basing on this, you can go on for selection? Then the 33% women who are already selected, because a merit list will be there. Examinations are, they write the examination. Basing on that examination, there will be some merit list. These posts are reserved. Once there are rules, once there is notification, there is a vested right that is created, because for me, in a particular zone, one post is allotted. Suppose I get a particular number of marks, I will be eligible to be considered for appointment. But suppose if this is struck down, her opportunity goes. Why should that situation arise? Third party interest will set in. Very complicated, and secondly, kindly see, now they will on some ratio, 1:100, one post 100 people or some ratio, they are allowing people to compete. That will have an effect on the number of persons being considered also. So everything is illegal. That list also is illegal. The arena that is open for the government to select will become narrower.
Such a stage has not come is my respectful submission. In a case where two individuals, as of now, though there are 4 petitioners in other case, only one is qualified in screening test. In this case, admittedly, one petitioner, at the instance of 2 individuals, if entire process is to be stayed or stalled, or if entire process is to be postponed,
then may I submit?
Therefore,
may make a alternative.
This is not a case where a notification is issued recently. 7/12/23 notification, almost 14 months after. I am not trying to justify the delay on behalf of government.
May I suggest, since counter is filed in one matter, that matter may be taken up.
Issue is
what is the harm?
I am horizontal reservation is concerned. In second case, it is always same issue is there, horizontal reservation issue, and repeatedly I am trying to submit, my lord. Their rights are not getting affected by virtue of their participation in the main examination. Main examination is meant for all posts. Applying roster points will only arise at the time of at least picking up candidates from the merit list of the main league. Yes. Insofar as if ultimately, if your lordship finds that this particular roster is wrong, it is always open to this honorable court. Normally, in various cases, after even after selection is made, if reservation or some irregularity or illegality in the selection process, normally courts are granting orders, redrawing the list and all those things. Therefore, my lord, at the instance of 2 petitioners, I will take it 5 petitioners.
Postponed twice, my lord, before this.
92,250. 250 minutes.
It's downloaded 74.
So far, 74,008 individuals have downloaded the hall tickets.
80% total.
Balance of convenience also, madam.
Twenty
23rd. Main exam.
exam.
Main examination. Thereafter, computer proficiency test is also there. This I am only trying to submit with respect to dates, time schedules. Thereafter, applying these roster points will Telangana High Court virtual mode is good. Merit. Their system will not allow the other individuals unless until their case is called.
Missing
Huh?
main advocate also. Because we will not be having option blood to log in on our own. But unless the court has said they allow. Yes, yes, I see. Let- One submission, one submission. So far as Millard, candidates being qualified in Millard, the preliminary test. Millard, they were not, they were disqualified not on the ground that they could not get any minimum qualifying marks or something. Randomly, they picked up Millard 92,000 candidates. It's not that Millard on their part, Millard not getting any marks. Marks have not been disclosed at all. Yes, randomly what they are Millard on the basis of total applications. Randomly, they are Millard calling for 92,000. So candidate.
That's a different cause of action.
Candidate. Yes.
No.
Out of 4 Millard, 1 is qualified. 3 Millard, they could not make application for these posts which have been reserved for Millard women and PW.
They are not qualified in the screening days, not because of roster points.
Yes, qualifications only will be scrutinized. They are not even being scrutinized now. Let the vacancies which are reserved for women. Let the petitioners cannot make even option for that.
That is the problem.
They cannot even make option in their application. Tomorrow, they will not even consider that candidate against that slot or post. If they have called for. Yes, yes.
Preferences will have to be mentioned. Preferences for all the posts will have to be mentioned. Social category should be mentioned. There itself, my Article 14 is scuttled. That is the whole emphasis of my submissions. So now we do not know on what basis they have fixed the ratio. Suppose there are 10 SC posts, they'll call for interview about 100 persons, which means this reservation will have the effect of the number of candidates who will go for the main examination. Kindly see.
Preliminary examination, but it's not as though APPSC picked up candidates randomly. They participated in the examination, preliminary examination. Yes,
Yes, madam.
yes, madam.
And 20.
Objective type screening test examination will be there. Basing on that, we do not know the marks. Basing on that, they prepare the list for main examination. Now, what has happened because of these illegal reservations, we could not opt for several posts. I may be selected, I may not be selected in the preliminary examination.
Such a
But
stage
when-
has not, such a stage has not come is.
Look, what I'm
After preliminary examination.
no, see, what has happened is this merit list that is now prepared, that is itself illegal because I did not get the opportunity to opt for all the posts. I suppose I am male ST. I cannot opt for women candidate ST women posts. I have not filed it.
Check of this reservation meant for women, the post allotted for women candidates, they are crossing 33 by 1. That can be seen later, after they failed. But at the inception itself, we are far from making application for that.
Paragraph 4. Not in the same terms that I have explained now, but pursuant to notification number 11 of 2023, dated 7/12/2023, I have made an application to the APPSC on 30/12/2023. I have also been given hall ticket for screening test. At this juncture, after close scrutiny of the notification, I have realized that the notification issued by APPSC does not provide equal opportunity to all the applicants in accordance with Article 14 of the Constitution of India, owing to the highly arbitrary and irrational fixation of roster points for reservation. The fixation of roster for vertical reservation is totally contrary to law, so and so. It adversely affects by right. That is very clear. And kindly see the notification itself, it says how Malad you will have to make an application. I'll just point out that. Yes. Kindly see page 55. 15.8. Post preferences and zonal preferences will be taken through online from the candidates at the time of main examination as well as the time of verification of certificates. However, the submission of option for post preferences and zonal preferences at the time of verification of certificate is mandatory and will be considered as final for selection. Candidates are required to visit Commission's website regularly for this purpose. So I give my preferences. That depends on the number of posts.
Plus may also see 15.9 merit.
One I'll point out. Page 112, my lord. This is APPSC has filed all these papers.
At the time.
They have their intents, letter of intents given by the various departments for filling up the posts. Since they did not follow GOMS number 77, they mistakenly pointed out the roster points for horizontal reservations. A glaring mistake. That comes out from this. Now, what can we deduce from this? Page 112. This is a public document now. Page 112, OC, there are 3 posts. All the posts are reserved for women. Now, if they conduct the main examination, will a woman not come and say, these posts are reserved for me? You have conducted the examination, but her interest will be affected. A third party right is created. We are complicating the issue more. Now, kindly see what happened. Page 112. This is the intent sent by the department to the APPSC. What did they do? Kindly see state cadre. But 5 minutes, 5. 1 OC. 3 vacancies are there. Kindly next. Roster point 56, roster point 57, roster point 59, women in brackets. There are no roster points. There cannot be because kindly see my paper book, Malad. What is the roster point? Kindly see there. Amended Rule 22. Open competition. And now kindly see roster point 56. What is there? But here it is reserved for women. Written with the pen. So we are creating third party interest. If the examination is conducted based on this illegal notification, these 3 women, Malad, tomorrow if the notification is set aside, these 3 women may get merit. They will say, I have lost it because of your notification. Why should we, Malad, give scope for such an allegation? Prima facie, there is evidence before your lordships that against Daria judgments, they have given letter of intents, maybe not intentionally. But this illegality cannot be perpetrated. That is my humble submission. Let the examination be deferred for a fortnight. This matter can be settled. This is not a stray incident that I am pointing out to your lordships. The whole matter, all these material papers are imbued with this illegality.
రాసింది ఎవరు రాశారు?
When such a
ఇందులో లేదు కదా, వచ్చిన అక్షరంలో ఉంది అది. But this W mentioned at page 112, whether it is written after receipt or not, whether it is there in the requisition. These are all requisitions sent by the concerned departments. These things cannot be basis for Lakshmi, see page 109 minute. Requisition form. This is requisition form sent by the concerned department. I learned friend may have to show it from the notification.
yes.
Not from this.
Yes, notification, it is clear. It exactly represents reflects the notification. Kindly come to page 57, my lord, of my paper book. My lord, 57. Municipal Commissioner, Community OC, 3 posts. Bottom OC1, the women, OC1, ST1, PBD1. ST, kindly see women. PBD, they changed it. So, but when it comes to OC, ST, ST1, that is given here. So this reflects this. ST, see, for okay, serial number 4, ST, roster point 58 for women. That is why they reserved it. And others, I have gone through all the material. Why will I submit, make a submission without any basis? All the intents are perfectly followed in the notification. I can demonstrate that. We'll go to another post. Kindly see page 120.
Right to be considered. Their right to be considered is not curtailed at this stage. I am only trying to.
Humble request in the event of your losses, staying the conducting of exam. The other petitioners 1 to 3 may be allowed for main examination because the screening at this stage is only on the basis of random access. That out of 4 lakhs, only 92,000. No, nothing has been seen about me.
They participated in the exam, they could not qualify. That's a different cause of action.
Permitting 3 candidates, it will not.
They notified on 10/4/24.
If they are not considered, if we are debarred from taking part in main examination, later we cannot, even if we say. From the fund.
Nice. Bless.
those three, my lord, if they are not, my lord, it cannot be, my lord, repaid later.